Okay, today is Sunday, August 25th, 2013. I was just wondering the fact that we have two time clocks and there's no time card or anything on the second time clock, and we're already on duty when we come to work, like I said before. Me and 400 other truck drivers, we're already on duty when we come to work. Okay, according to the Department of Transportation regulation and company policy and union contract, you will follow Department of Transportation. Now we have to clock in and out of that time clock, and there's no time card. And the automatic recording device or the recorder in the tractor is tamper-proof. Tamper-proof. There's no way you can alter or change anything on them logs. The driver can't do that. He can't do anything. It's automated. Okay, so you can't falsify anything on that tractor, no matter what. You can come in at 10, 11, 12 o'clock. It doesn't matter. It's going to start at 10:30. And I don't understand what this is really all about. I can't figure it out. I don't have anything in writing explaining to me why I deserve any type of disciplinary action whatsoever because of that second time clock that has no time card. It doesn't record anything. It doesn't do anything. Okay, and as we all know, like I said before, the trip sheet they only pay you by the miles. It doesn't record anything from the second time clock. So there's no way of knowing that you ever got paid or how much time you put in, other than the fact that it's going to be a mismatch on the trip sheet. Because when you log out of that tractor, you're off duty leaving Tracy. But it's a lie. It's not true. You're not leaving Tracy because you're still on duty because you're instructed to clock out of the second time clock in the driver's room. Now, that being said, I don't know what to think. I don't even know what's going on. I mean, they didn't give me nothing in writing. They explained to me why this or why that. I just follow instructions, just like 400 other Teamsters and truck drivers there. We just do what we're told to do, and we do it. For them to take the time off the second time clock and alter or falsify my logs and then not make me aware of the fact that that's what they did and write it down in the remarks section is wrong. Okay? It's completely wrong. It's not right. And I think they're just doing this because I have a disability. They didn't follow the time limits. They didn't notify me within 10 days, and I should have been put back to work like 1,500 other Teamsters. I don't know. I called Mike Sadler on the 10th day. I called him. I called him on the 16th. I have telephone records to establish the fact that I called Nightwater on the 16th. And my wife was here, and there was other people here, because I want to verify the fact. I want to know what's going on so I can get back to work. But Nightwater said he hasn't heard anything on the 16th. That's when Mike Sadler made out the agreements. On the 16th, that's the 10th day. It's got to be within 10 days. The union didn't receive it until the 17th of December, 2010. That's 11 days. I should have been put back to work like 1,500 other Teamsters, but they didn't put me to work, and they didn't explain anything. They didn't give me anything in writing, and I've been trying to tell them for the last 3 years that they didn't file agreements within 10 days. I going around and around and it just boggles the mind what the heck's going on. So I have to get this notation down correctly. I'm going to try for court. I go to trial because I need somebody to explain it to me. Maybe they have to explain it to me in trial. If that's what needs to be done, well, then it needs to be done. But I got to tell you, I got the document that shows that union received it, stamped received the 17th of December 2010. That's 11 days from the date of incident. And the incident is December 6, 2010. Now, from December 6, 2010 to the 17th of April, 2010 is 11 days. They didn't file a grievance within 10 days. And they didn't file within 10 days like they were required to do, to provide documents, evidence, photos, etc. by the 26th of December 2010. So they violated step 1 and step 2 of the contract, you know. So Article 25 and 26 is what it is. So, and all articles of the contract, they violated everything. But the point is, that second time clock doesn't do anything, and I don't even know what that's about, really. I can assume anything. I can assume that he's saying that I punched in late. I can assume that I was drunk. I can assume anything, but I didn't. I'm not going to, because it's ridiculous. There's no time card. And me and 400 other drivers, we just do what we're told to do, and now he wants to use it for whatever, I don't know. See, I'm stumbling at work because I don't know what he wants, what he's doing. He didn't explain it to me. He didn't put it down. No representation, no nothing. I don't know what the hell's going on. And Jesus Christ, man, somebody ought to do something. I mean, they ought to get testimony from the drivers. If it's not within 10 days, the driver's put back to work immediately. There's no doubt about it. That's the contract. So they didn't follow the contract. The second time clock, there's no time card, and the drivers and myself, for 400 plus drivers, and myself haven't been paid, and I haven't been paid in the last 10 years by that time clock, and we should be getting paid by the hour for services rendered. But we didn't get paid. We haven't been paid. Now, we follow the union contract. We follow company policy. I do what I'm told to do. We have a no fault attendant policy that's been there for I don't know how long. And I don't get it. I don't get it. And, you know, I'm not going to contact Mr. Nicewonger because my attorney sent me to report to work. Because Mr. or Mrs. MORLES of Safeway Private Insurance in Arizona sent a letter to my attorney to report to work. So I report to work. And Mike Sadler says, I don't know anything about it. And the union doesn't do anything. Mr. Nicewonger says he don't know anything about it. And I don't really recall if he said he was going to look into it or do this or do that. But I haven't heard anything. I'm still sitting here. So, I don't understand why Mr. Nicewonger didn't say something when I called him on the 10th day. He should have had me put back to work. Why he didn't put me back to work is the judge is going to have to ask the question. Why didn't Mr. Nicewonger put me back to work on the 10th day when I called? And I guess I'll have to produce the telephone records. But, I just don't know what's going on. So that's why I'm making this notation, is the fact that I called Mr. Nicewonger on the 10th day. I have telephone records to establish that fact and witnesses, and the fact that he didn't put me back to work, or the company refused to put me back to work, one or the other. And the second time clock, those issues haven't been resolved by the union, and they laid it on Workmen'S Comp to resolve those issues. Disability issues, I suppose. I guess they might not deal with the second time clock. I don't know what authority they have. Maybe they don't have any authority at all. Maybe they're just going to deal with disability issues. And if that's the case, they still have to put me back to work. It doesn't matter. I have a permanent disability. I have a hearing impairment. I was on FMLA, and I wasn't fired on December 6th or December 7th. I was just flat out sent home, and I worked the whole year of 2010. And the QME report that goes along with the notice of offer of work states I can do my customary duties. So I should be working. And I'm supposed to work first and grieve later. That didn't happen. So why am I not working? I don't know. I don't know. I'm stumped. I really don't know why I'm not working. And there's no disciplinary matter. All issues are dropped because they didn't reply within 10 days. So there's no issues other than I have a disability. So it's obvious they're not putting me back to work because I have a disability. And that's the bottom line of this notation for court. The reason they're not putting me back to work is because I have a disability. And so I guess I'll have to wait till I go to trial and let the court make their decision. But the fact is, beyond a reasonable doubt, they didn't file a grievance within 10 days. Beyond a reasonable doubt, I called on the 10th day to Mr. Neiswanger, and he said he hasn't had anything or he didn't hear anything. Okay, that's fact 2. Fact 3 is that they didn't receive the grievance until December 17, 2010. And the incident was December 6, 2010, and that's the date that the dispatcher took the time from the second time clock and altered my time on my logs. And as I said before, I went to the Highway Patrol Office, Department of Transportation, and they said that it appears that my logs were tampered or altered with. So we don't need to go into that. According to 395.5, 395.16, and 395.8, according to that regulation, the dispatcher is the only one to hit the key, and he took that special privilege and he falsified my logs. Now, I don't know what more I can say to the fact that I need to be returned to work, and the notice of offer of work used to be enforced for 1 year, and that I should get all back pay from December 7th, 2010. And what about from 2002? I don't know because there's no time card for December 7th, 2010. So the question arises: am I going to get paid from 2002 or December 7th, 2010? So I don't know how they're going to deal with that question or how they're going to act on it if they do at all. I know that they should pay me from December 7th, 2010, but there's no time card. There's no trip sheet. I didn't see anything. I didn't get anything. I got nothing in writing. So I should get all back pay and benefits and everything from 2002 or from December 7th, 2010. So that's for the judge to decide. Now, I guess that's going to be my statement for the court. I don't know what else to do. I'm sitting here waiting for a telephone call or registered mail to report to work, and it hasn't happened. And I've been off work for 3 years, and I haven't had a paycheck in 3 years. I have not had a paycheck in 3 years, and I'm not on disability. I am not on disability. So an insurance company hasn't sent me any money, and I don't know why they should because I'm not on disability. But then again, I don't know workman comp rules and regulations. But before they sent me home, on December 7, 2010, I was collecting unemployment, and the unemployment office said they were in conflict of liability. And then I had to file when they sent me home on December 7, 2010, and the unemployment office states that they were in conflict of liability again, that I should be working. There's no doubt about it. I should be working. That's the state's position with the unemployment office. So, Christ, I don't know. I'm going on 3 years here, and I need my lifetime medical insurance. So I need to go back to work in order to obtain my lifetime medical that I paid for in 2002. So I don't know what's going on. I have nothing in writing, nothing. bog miling. When I go to the psychiatrist, I'm going to present him with the documents showing that they did not file a grievance within 10 days. I'm going to give that to the psychiatrist. I'm also going to give the letter that I was sent to the attorney to me, and I don't know to my attorney or not, the letter that's stating that I was fired on December 16, 2010. I don't know how that could be if the grievance was made out on December 16, 2010. And that was the 10th day. That was the 10th day. They should have put me back to work. It says within 10 days. That's not within 10 days. So the attorney sends me a letter saying I'm fired on December 16, 2010. Mike Sadler makes a grievance out on December 16, 2010. The same day the attorney said I was fired, and the grievance was received by local 439 on December 17, 2010. That's 11 days. It's not within 10 days. Now, I'm assuming that the union attorney made a mistake, but that's not for me to say. And so I guess I'll have to leave this up to the judge to decide what's going on here, because it's confusing and they're not following the contract or contractual procedures. And Mr. Neiswanger should have sent them a letter for me to return to work when I talked to him on December 10, 2010. And he didn't do so because I'm not working. I'm sitting here and I don't know why. So if Neiswanger is going to take any action about that, and the fact that they didn't finish the panel hearing, and due to the fact that I have a severe profound hearing impairment, and they didn't accommodate me, and I mentioned to him when I was there with a letter from the attorney to report to work the fact that I have a legal document. So I'm not clear about that, but I'm assuming that that's what I told him. But in any event, I had a letter from the attorney to report to work. He should have looked into it. He should have called my attorney and find out what's going on. If I have a legal document that I'm deaf and this and that, he should have talked to my attorney, Modesto Legal Clinic. But I don't know if he did or he didn't. And in any event, it's not within 10 days. And I should be returned to work like 1,500 Teamsters. And it wasn't done. And the second time clock is tamper-proof. You need a key in order to change anything on them logs. So the driver and the dispatcher didn't make me aware of anything on December 7th, 2010. So that has got nothing to do with my disability. It's just the fact that if he tries to say something, I don't know what he's talking about. He can tuck his head off all he wants like he did on December 7th, 2010. He was ecstatic. That guy was just, I don't know. I don't know what I walked into. I have no idea what this guy's yelling about, okay? There's no time card on that second time clock. And on the trip sheet, it only pay you with trip miles, and there's a mismatch. If you look at the trip sheet, you'll see where the driver logged out, and then there should be a second time on the bottom of that time, indicating when the guy clocked out of that driver's room. In the driver's room, he clocked out. Now he should be getting paid by the hour. He should be getting paid by the hour because he's not getting paid by the trip sheet because they only pay by the mile. So the difference between the time the driver logged out of that truck and the time that's written in or printed in underneath it when he clocked out of that driver's room should be paid by the hour, because there's no proof that he ever got paid because the logs are not recording anything. They're not recording nothing when he logged out of that truck. It says leaving Tracy. It's a lie. The driver's not leaving Tracy. It's a violation of Department of Transportation regulation. And I don't know why nobody's looking at it. Mr. Neiswanger should check it out. But the Workmen'S Comp don't handle union issues. They only work with disability issues. And I have an issue with disability, and the union admits that. So they laid it on Workman's Comp to put me back to work. And I hope Workman's Comp puts me back to work because we have a contractual agreement that if it's not within 10 days, I'm to be put back to work like 1,500 other Teamsters. And the Workman's Comp judge should follow the contractual procedures and put me back to work. And then the hearing impairment violation of 132A, I don't know what he wants to do about that. But I'm asking the judge to put me back to work because I was on FMLA. They violated the 10-day time limit. They didn't produce anything on the December 25th or 26th, 2010. No evidence, photos, or documents stating what my disciplinary matter is or should be or was. So it's null and void, final and binding. All issues are dropped. There are no issues other than the disability and the fact that they didn't follow contractual procedure. They didn't file agreements within 10 days. So that's my notation for trial. And I'm gonna, I invoke double standards. I invoke double standards. Life is not fair. And I'm asking that the court to take that into consideration and return me to work according to the contract and according to Workmen's Comp rules and regulations. That's my statement for trial.
I'd like to know one thing. I'd like to make a correction on that last recording. Instead of trip sheet, it should say logs. Logs. When everything had to be recorded, you get paid by the logs. You only get paid trip miles. Now, when you log out of that truck, it says leaving Tracy. On the left side of that log down below, there'll be a different time. The time will be from the time clock in the driver's room. There's a mismatch. That time when it says leaving Tracy to the time that you log out of that driver's room should be paid by the hour. Should be paid by the hour, and there's no time card. You should get paid for services rendered, and it's not being done. So I like to make that correction. And two, it's like I said, it was time limits. They violated time limits. They should have been returned to work. And that's the bottom line. All issues are dropped. I should be working no matter what. The State Department of the Unemployment Office, they said they're in conflict of liability. I should also be working. And also, Mr. Nicewanger sent the letter on December 17, 2010 to James Williams, the transportation manager, to put me back to work immediately. And he didn't do so. I'm going to give a copy of that to the psychiatrist to back up what I'm saying. Okay, so I should be working all this time because they're in contractual violation, and they didn't put me back to work at least 3 or 4 times when they were told to do so, including administrative judge while Judge Grill was off sick. So why I'm sitting here waiting for a phone call and registered mail, I have no idea. This is mind-boggling. I don't know what's going on. So when I get to the psychiatrist, I'll produce all documents. And like I said before, I, Julio Zamora, invoke double standards. Life is not fair.
Okay, I'm just going to add this to the end of that recording. I'd like to remind the court the fact that when I was sent home on December 7, 2010, when I received the QME report on December 1st, 2010, it wasn't complete. The QME report was not complete because the doctor, I forgot his name, said that he doesn't do hearing tests. And I received that on December 1st, 2010. Like I said, a short story. I don't want to make a long story out of a short story. The fact is that the QME report wasn't complete. They offered me work for 1 year, and I needed it enforced. Because the QME report wasn't finished yet. They just flat out sent me home. And I'm sitting here, and I don't know why I'm sitting here. They violated all the time limits, They didn't produce any evidence of what my disciplinary action is to be or what it was by December 25th, and at least they had to put something in by December 28th, within 10 days. They didn't do so. They didn't do anything. They went around the Board of Adjustments, and that has time limits within 30 days. They didn't do that. They just didn't do anything within the time limits. And I don't know why I'm sitting here waiting for a phone call or registered mail to report to work when I have 200 employees underneath me. Now, James Williams, the transportation manager in Tracy, California, knows all this. He should have returned me to work like he does for 1,500 other Teamsters or 400 truck drivers. If it's not within the time limits, they're returned to work immediately. If it's not within the time limits, they're returned to work immediately. Now, I should note for the record, in Administrative Judge Grill, the fact that I don't know why I'm sitting here. They didn't produce anything. I never received any registered mail whatsoever of any suspension or discharge within the time limits. I did not receive one document of why I'm sitting here waiting for a phone call or registered mail to return to work according to the notice of offer of work that I asked for Eureka Run at 10 o'clock in the morning. And I'm still sitting here waiting. So I should get all that back pay because they didn't comply. 3 times they didn't comply. And I hate to keep repeating myself, but my life is on the line here. And I don't know why I'm sitting here. I don't have one document. Not one document for suspension or discharge, or the reason why I'm sitting here by registered mail within the time limits. Not one. And I'm still sitting here. So I should get all that back pay and benefits, and I hope Administrative Judge Grill returns me work according to the notice of offer of work that wasn't complete. They just flat out sent me home. And so I'm not going to go into it anymore about the deposition that I wasn't accommodated or anything else, and I need to take another deposition for the record. And that I have a new attorney, Modesto Legal Clinic, who took my case. Obviously, by my statement, you know why. The fact that Judge Grill didn't have nothing on the table, not my severe profound hearing impairment or the notice of offer of work. And that if it's at all possible, if Judge Grill could agree to the fact that Safeway should pay all attorney fees and expenses to Modesto Legal Clinic for all their hard work and getting me to be returned to work. For the fact that Adam Stewart, I feel that he failed in his responsibility by not getting me a hearing test or not mentioning the fact to the Administrative Judge Grill that the QME report was not complete, and I didn't get paid every week or every 2 weeks, and that they're in conflict of liability with the EDD, Department of Unemployment, and he didn't mention one word about it since 4/17/2009 and ongoing, and I received another document from EDD saying that Safeway is in conflict of liability. I should be working. So with that being said, and the fact that Safeway doesn't want to comply, and it's just more time and money for Modesto Legal Clinic, who's representing me. And I don't feel I should have to pay Adam Stewart anything. So, but that's for you to decide what is fair and equal under the law. And your decision, I agree to accept your decision, whatever is reasonable under the law. But I do request to go to trial to hear the case for the Two Disability Act of 2009. Anyways, like I said, I I have permission, or I was instructed to pursue this by the union attorney on workman's comp, and they're aware that I have a disability issues. I exhausted the union remedy. There's no remedy under the union to return me to work because I have a disability. And so they're not going to deal with it, and they threw it on workman's comp's lap. So, and the fact that I told them that I had a severe profound hearing impairment and that wasn't acceptable, even though I sent them a prescription and the test results to the union attorney, and it wasn't accepted, and they denied me arbitration. And so I, Julio Zamora, invoke double standards. Life is not fair. Okay, today is Friday, March 1st. Making a statement for Judge Grill Settlement Conference in Stockton, California. On 3/21/2009, I was injured on the job, and I went to see Nancy Perdillo, and she stated that it was a sprain. I don't recall going to the hospital or an MRI being taken at that time. And she's an alcohol and drug technician, which gives you tests to see if you were on drugs or alcohol at the time of injury. And there was no doctor present. On maybe a week or 2 weeks later, I ended up in the Los Angeles Memorial Hospital with severe pain. It was really, really bad. I couldn't take it anymore. So I was there all night long, and they took an MRI and discovered the fact that I had a pinched nerve. They took an MRI the next day. I went in there for left leg pain, the same thing I'd seen Nancy Perdillo for in Tracy, California. Drug and alcohol technician who said it was a sprain. Now, I'm not going to go into the PR2 report because it's incorrect and it wasn't completely signed properly. And the fact is, I had a treating physician that I signed for good for 1 year, Paralosi, chiropractor. That if I get hurt on the job, that I'm to go to the company doctor for 30 days, and then the chiropractor is to take over. Okay, so and the Los Angeles Memorial Hospital made out an occupational report stating the fact that I went in there for left leg pain, and that I have a low back, a pinched nerve. And I don't remember who I got the referral from, if it's Los Angeles Memorial Hospital, what doctor it was, or if it was Dr. Yip or Perlosi, but they gave me a referral to Dr. Baby, and to fix the pinched nerve, it's a walk in and walk out type deal, and I was denied by Safeway, and they sent the letter to the wrong person, to Dr. Hubby, asking her if it was job related, the pinched nerve, and they should have sent it to Nancy Perdillo, the drug and alcohol technician, but they didn't do so because she's the one that said it was a sprain. So, okay, I haven't been paid every week or every 2 weeks disability payments since I would say since 3/21/2009 or 4/17/2009. I had to file for unemployment, and they sent me a letter stating that Safeway was in conflict of liability, and they sent me another one in 2012 or 2013 that Safeway is in conflict of liability. I should note that I have a notice of offer of work that I received on December 1st. December 3rd, I went to work. On December 7th, 2010, they flat out sent me home. Just flat out sent me home. I had no representation. And the fact is, I was supposed to work first and be later. That didn't happen. They just flat out sent me home, and they made false accusations. And this is all disability related due to the fact that I filed in 2009 severe and profound hearing impairment from reaper noise. Come to find out at the settlement conference, Judge Gross Court suggested that I get a legal document for severe and profound hearing impairment, and come to find out that I've had a hearing problem since 2006. I needed to be accommodated with a listening device because I have a more than a 50% hearing loss in both ears. And I should note also for the record, since 2006, I have never been accommodated with any sort of listening device or hearing aids or anything else for that matter. It wasn't taken serious by the union or the company. But due to the fact that they had a panel hearing, they flat out sent me home when I mentioned the fact that I had a severe profound hearing impairment, and I asked the job steward, are you an authority on severe profound hearing impairment? And Mr. Neiswanger, the PA from the local 439 Teamsters in Stockton, California, which is a union shop, was there also, plus another shop steward was there when I made that statement. And he said he's going to look into it, and they just flat out sent me home and didn't accommodate me. And I should also note the fact that they didn't Safeway didn't follow contractual procedures. I was denied to return to work because they didn't comply with the time limits, like they do for 1,500 other teamsters. I'll return to work immediately if they violate the time limits. They didn't do so. I should also note that they're required to go to Board of Adjustments for all suspension and discharges within 30 days. I should note that on December 17, 2010, Mr. Neiswanger sent a letter to the terminal manager, James Williams, that all disciplinary action to be denied and to send all proof, photos, evidence, whatever you have by December 25th to establish a fact beyond a reasonable doubt that Mr. Zamora did wrong or deserved disciplinary action, and to set a time and date. Well, the terminal manager, James Williams, did not comply. He set a date for January 11, 2011. I should note that's not within 30 days. According to the contract, all Board of Adjustment suspension and discharges are to be heard within 30 days of date of incident. And they didn't comply with time limits or anything else for the record. And on top of that, I was never notified that I was ever discharged by registered mail. I was never notified that I was ever fired, discharged, or suspended by registered mail, according to time limits. Okay? And so going from there, they didn't honor the notice of offer of work. They didn't apply, even though they made an agreement with Workmen'S Comp to work me for 1 year. And it was deemed accepted whether I turned it in or not, and I had 20 days to comply or think it over if I wanted to change a job or retire, etc., etc. Well, I asked for Eureka Run 10 o'clock in the morning bid, and that I was hired in 2002, and that I had 200 employees underneath me, and there was work available, and that anybody who works underneath me, I get paid for that day, and it's a 24-hour operation, 24 hours a day, and there's 400 truck drivers there. And I should note that I've been waiting for a phone call or registered mail to return to work, in which they are not complying with the notice of offer of work, and they're not completing their agreement that they made. In other words, they're in violation of their own agreement. So I needed to be enforced by Judge Grill in the settlement conference. I'm waiting for a court date from Modesto Legal Clinic because we were waiting for a document to get a legal document stating that I have a severe profound hearing impairment, which states that I had a hearing problem since 2006. And they haven't accommodated me with any listening device or whatsoever since 2006. Okay? So on December 7, 2010, they just flat out sent me home and they didn't pay me for the day. And I wasn't represented by the union on interrogation by the dispatcher. He told me the shop steward is on his way, and he told me to sit down. And I was supposed to work first and grieve later. It didn't happen. And they just flat out sent me home. And again, I hate to repeat myself, but I have a severe profound hearing impairment. the panel hearing was put in abyss, and I told them, are you an authority on severe profound hearing impairment? And they just flat out sent me home. I had a settlement conference, and Judge Bill was off that day, and Adam Stewart was my attorney, workman comp attorney at the time. The administrative judge suggested that they put me back to work due to the fact that the Safeway attorney was on the phone with Safeway, and Adam Stewart approached me, and my wife was there and asked me how long I could work for. And I thought that was peculiar because I had a notice of offer of work guaranteed or work for 1 year. Which they didn't comply to. So that was the second time. The first time they violated the time limits in the contract, and they didn't put me back to work like they did for 1,500 other Teamsters. The second time was the administrative judge suggesting that they put me to work, and the Safeway attorney must have told Adam Stewart, I don't know, because when he asked me how long I could work for, and he left, a lady or his secretary came up to us and told us to go to the lunchroom, and then later told us to go home. So that was the second time. The third time, Mr. and Mrs. Morles, Safeway Private Insurance from Arizona, sent me a letter, or sent my attorney a letter, honoring the notice of offer of work, suggesting that I should sign it and send it to Arizona, which I did registered mail in 2013. My attorney, Modesto Legal Clinic, sent me a letter to report to work immediately. I did so. Safeway and the union did not comply, or the union didn't take any action, and even though that they were aware of, or I made them aware of, that I had a severe profound hearing impairment to their attorney, and I also sent them a copy of a document of an examination showing and stating with a prescription that I had a severe profound hearing impairment, and they ignored it. In fact, I asked for arbitration, and the union attorney denied it, but suggested or mentioned the fact that we know you have a disability issue, and that arbitration is refused, and that you could pursue it under workman's comp if you wish to do so. At that point, I figured I exhausted the union system, whatever it is. I exhausted it, and now it's in workman's comp's lap. So at that point, they didn't comply. They put it on workman's comp to comply, so I'm asking workman's comp to enforce the notice of offer of work, and I'm asking for trial, because I'm assuming the fact that they're in violation of 2009 Discrimination Act against the severe profound hearing impairment of people with hearing impairment, and that the union did not comply with federal law. So I could be wrong or I could be right, I don't know. So, but I'm asking to go to trial so that the judge can make a decision on that, for the fact that I've been sitting at home waiting for a phone call or registered mail to report to work since December 7, 2010, and I need a court order to get all back pay and benefits 7 days a week, 14 hours a day, plus my lifetime medical to be restored, medical, prescription drugs, Delta dental, eyeglasses, and I don't know about hearing impairment, and then I'm at 90%, so I don't know what the court wants to do about that, but I'm asking for it to be reinstated. And the fact is, I'd like to make a notation for trial. Add this notation to the recording I just made. And today is Monday, April 22nd, 2013. Just add this recording to the notation I just made for the fact that I should never lose my lifetime medical that I paid for the last 10 years. And the fact that I should have some protection from the court, that whether they retaliate on me or they send me home or quit or fired, whatever, I should have some protection from the court, that I don't lose my lifetime medical for life with no premium. I don't pay any premium when I retire. So that should be protected no matter what happens in the future, that I don't lose my lifetime medical, that I'm covered. under health and welfare for life. Whether I'm working or not, it shouldn't be stopped no matter what. Okay, because I have a disability and I have a hearing impairment. And I paid for that. That's a lifetime medical plan. I should have some protection from the court. Uh, so I hope the court can decide on that lifetime medical plan, that they're not allowed to take that away from me no matter what, whether I'm fired or sent home or I quit or no matter what. My lifetime medical plan is to continue on without a break in service. So I'm asking for that. If the court can make a decision on that, I would appreciate it. Due to the fact it's a union shop and that they discriminate against me, the union. So I don't know why they didn't accommodate me or anything else and took and lost my lifetime medical. Um, it's wrong. I'm asking for some protection and no breaking coverage if I should be sent home or they retaliate or I quit, whatever. No break in lifetime medical plan. That it should be continued on for life because I have a permanent disability. That's my notation to be added to the last recording. And I should note that I, Julio Zamora, invoke double standards. Life is not fair. Due to the fact that all disciplinary action was denied on December 17, 2010, because the grievance was received by Teamster Local 439, Mr. Nicewanger, on December 17. It was stamped received Local 439 on December 17, 2010. That's more than 10 days. And I should note they didn't respond in 10 days on December 25th, 2010, when they were required to do so according to contractual procedures, and they violated the time limits and also step 1 and step 2 of the contract. And I should also like to note, for the record, that the fact that any documents or any evidence or statements that's not received by December 26, 2010, not to be valid and not to be accepted by the court, due to the fact that they didn't follow contractual procedure or time limits. Due to the fact that they didn't follow contractual procedure or time limits. They didn't produce anything by December 26, 2010. And all issues are dropped. Null and void, final and binding. There are no issues after December 26, 2010. And which they didn't comply, and the union didn't enforce contractual procedures, let alone a hearing device or assisted hearing device at the panel hearing, and they put it in a fist and sent me home. So I'm asking to go to trial for the court to get a court order for back pay and benefits and automatic retirement on my birthday on September 7, 2013. And that everything to be restored, back pay and benefits and pension and RSVP. I don't make any payments as the premium lifetime medical. I need that reinstated, and I don't make no premium payments after I retire. None. And I need that reinstated or made whole again, including my pension, my back pay, and health and welfare to be paid. Because my wife is sick and she ended up in the hospital, and it's really hard. I have to pay for that bill. So if they could pay for the health and welfare for the year of 2013, I would appreciate it, and then I wouldn't have to make payments to the hospital. And the union put it on Workmen'S comp to resolve these issues. They said I could pursue it under Workmen'S comp, so that's why I'm bringing all that up in the union matter. I'm bringing it up for the fact that they didn't deal with the issues of severe profound hearing impairment, and the fact they didn't deal with the issue, the fact that the dispatcher on December 6, 2010 changed the time on my logs from 10:30 to 11:15, taking the time from the second time clock. I should note that it put me in violation of Department of Transportation and company policy. And he accused me on December 7, 2010 of falsifying documents or intent to falsify documents that he altered or falsified on December 6, 2010. And I should also note that the onboard automatic recording device in the tractor is tamper-proof. Tamper-proof. And you also have to have a key in order to change anything. And the dispatcher is the only one with the key. I'm assuming that's correct because I've seen them change the time on logs before. And I'd like to note also that we get paid by the trip sheet. The trip sheet that belongs to the tractor that prints out logs. I should note that they don't pay delay, they just pay trip miles. Sometimes they pay delay, sometimes they don't. So my point being is the fact that when we log out of that truck, we're off duty. Now, if we log out of that truck, we're off duty and we're required to clock out in the driver's room and clock in. Why, I don't know when we're already on duty. The fact is, it's not being recorded. And we're not getting paid by that second time clock. I haven't been paid in the last 10 years, myself or 400 other truck drivers. I should note that the time clock in the driver's room, we're required to clock out. When we log out of that truck, we're still on duty according to company policy or instructed to do so, myself and 400 other truck drivers. When we're logged out of that tractor, we're not allowed to go home. We have to clock out of and check in the driver's room and clock out, and there's no time card. We don't get paid by the hour when we should be getting paid by the hour for services rendered, but we're not. And I was sent home on December 7, 2010, and I didn't get paid for that day, and there's no time card. In fact, there's not even a trip sheet for that day. What happened to it, where it went, I don't know. But in any event, I should get all back pay. There's no doubt about it. Okay, and the dispatcher is guilty beyond a reasonable doubt because he altered my logs by taking the time off the second time clock and changing the time on my logs, which is not required to do so or has the authority to do so according to the Department of Transportation Regulation 395.15, 395.16, and 395.8. He's not allowed to alter or change anything on non-logs. And if he is, he's supposed to make the driver aware that he did so. And he didn't make me aware on December 7, 2010 what he did on December 6, 2010. And again, I was not fired on December 6, 2010 or December 7, 2010, for the record. Or corrected him, whatever the case is. I don't know what authority they have on changing laws. Under the Department of Transportation 395.15, 395.16, and the interpretation in 395.8, it states in there that they're not allowed to alter or change anything on them laws. If there's a problem, there's a right in the remark section what the problem is. And what the problem is, and make the driver aware. They didn't do so on December 7, 2010. And so I should note for the record that they didn't honor the notice of offer of work at least 3 times. They denied to put me back to work. And that I have a permanent disability according to the QME report. And that it states in there that I can do my customary duties on my job. And I should also note that according to the legal document that I have that was requested by Judge Grill in the settlement conference to 2 attorneys that I just received, that I have a severe profound hearing impairment since 2006, and that I lip read. I'm not good at it yet, but I'm learning, and I'm also trying to learn sign language. But the point is, I've never been accommodated at any time since 2006, and they need to accommodate me with hearing aids. Because I bought my own, and they're old, and they don't work at all. And I need something that blocks out background noise and stuff like that from the reaper. So again, I'm asking for a court order to be returned to work, all back pay and benefits, and health and welfare, and my lifetime medical, according to the 2009 Disability Act, and also to the contract, okay? Because I didn't do nothing wrong on December 7, 2010. The only thing I received was a notice of offer of work, and they just flat out sent me home, and I was also on FMLA. So this is my request for trial, for Judge Bill to consider sending this case to trial to resolve the issues of the Disability Act of 2009, hearing impairment. I would appreciate it if we did that, and I also would appreciate the fact that he enforced the notice of offer of work and returned me to work according to the contract. And I would appreciate that. And I should point out that the fact is that they've been refusing me, denying me medical treatments. I don't get paid every week or every 2 weeks in 3/21/2009 or 4/17/2009. They refuse me to put me back to work when I have a full duty release to go to work. They won't accommodate me with hearing aids. They won't honor the notice of offer of work. I hate to keep repeating myself, but I do have a severe profound hearing impairment, and my life is on the line. And I need the notice of offer of work to be enforced for the fact that my daughter needs 1 more year at the university to get her BA in biology. 1 more year. I need that 1 more year. And they made an agreement with Workmen'S to work me that 1 year. And I'm asking for it to be enforced so that my daughter could university. And that was a guarantee for 1 year. And I didn't start 1 day on the 10 o'clock shift Eureka run. So I'm asking Judge Bill to consider that. And I'm also asking him to consider the fact that a double standard is the application of different sets of principles for familiar situations or 2 different people in the same situation. A double standard may take the form of an instance in which certain concepts, often, for example, a word, phrase, social norm, or rule, are perceived as acceptable to be applied by one group of people, but are considered unacceptable, taboo, when applied by another group. The concept of double standard has long been applied, as early as 1872, to different moral structures on men versus women. A double standard, thus, can be described as a sort of biased, morally unfair suspension towards a certain group of the principle that all are equal in their freedoms. Such double standards are seen as unjustified because they violate a basic maxim of modern legal jurisprudence that all parties should stand equal before the law. Double standards also violate the principle of justice, known as impartiality, which is based on the assumption that the same standard should be applied to all people without regard to subjective, bias, or favoritism based on social class, rank, ethnicity, gender, religion, sexual orientation, age, or other distinctions. A double standard violates this principle by holding different people accountable according to different standards. The phrase "life is not fair" may be invoked in order to mollify concerns over double standards. I'm hoping that Judge Bill considers this statement for the fact that if the company doesn't comply with the time limits under the contract, 1,500 Teamsters are returned to work immediately. Well, they didn't put me back to work. And James Williams, the transportation manager, he knows everything. He knows what's going on. But he didn't comply. He didn't put me to work, back to work like they do for 1,500 Teamsters or 400 truck drivers. I should note that for the record. And I should also note for the record that they didn't accommodate me with any listening device whatsoever since 2006. So I'm asking Judge Bill to consider this and to enforce a notice of offer of work because my life is on the line here and I have no lifetime medical, I have no medical coverage whatsoever, even though I paid for it in 2002. I paid $3,000 plus to cover for 5 years so that I can retire at any time. And I should also note to the fact that Safeway called to health and welfare and said I didn't work at Safeway. And that barred me from getting any kind of lifetime medical or asking them to keep me covered. That didn't happen. So, and the fact that the dispatcher who falsified my log by taking the time off the second time clock, and they have a no fault attendance policy, and they applied it to everybody else, but they didn't apply it to me. No fault attendance policy that's been as part of the company policy for 10 years that I've been there, and from my understanding, it's been on there for at least 20 years. No fault attendance policy. So, and the fact that I never received any registered mail or anything else stating that I didn't work at Safeway at any time, not within the time limits. Okay? So, and the fact that they just flat out sent me home and they didn't pay me on December 7, 2010. They took my time card or my trip sheet or whatever it is and disposed of it. I don't know where it went, it disappeared, and I never got paid for that day. So that's why I'm asking for back pay from December 7, 2010. And I hope Judge Bill considers again to enforce a notice of offer of work and then to send this case to trial. And I will hope he considers this seriously for the fact that I have a hearing impairment and that the union should be held responsible under the Disability Act of 2009. And that's my statement for the court. So I hope Judge Bill considers the double standards.
I should like to note one thing, that I stand to be corrected by my statements and everything, due to the fact that I have a notice of offer of work that I received on December 1st, 2010. Mike Sadler and James Williams are well aware of the fact that I have a notice of offer of work that I'm guaranteed for 1 year, and they refuse to comply. And I'm sitting here waiting for a phone call or registered mail to report to work, and they refuse to do so. And I should also like to note for the record that any statements or documents that's not handed in before December 26, 2010 should not be accepted by the court. Because anything not sent in by December 26, 2010, okay, is null and void, final and binding, and all issues are dropped. And James Williams and Mike Sadler of the Safety Department and James Williams of the Transportation Department, the manager, knows all this. But it doesn't matter. They refuse to put me to work. They refuse to comply with contractual procedure or workman's comp rules and regulations. Now, again, I repeat myself, I stand to be corrected, but I'm asking the judge not to accept any documents that's not dated before December 26, 2010. And I hope he considers double standards. I, Julio Zamora, invoke double standards. Life is not fair.